Welcome back to Cracking the Code 3rd edition. We are in the glossary starting on the T's. Tax. A rate or sum of money assessed on a citizen's person, property, or activity for the support of a government levied upon real assets or real property, property tax, upon income derived from wages, etc., income tax, or upon sale or purchase of goods, Barron's 3rd. See note. Note, under the current debt-based system and commercial law, tax, lien, and fine are synonymous terms. Tax return. The form on which an individual, corporation, or other entity reports income, deductions, and exemptions and calculates their tax liability. A tax return is generally for a one-year period. However, in some cases, the period may be less than a year. A federal tax return is filed with the IRS, the Internal Revenue Service, and a state return is filed with the Revenue Department of the state. Black 6. See note. Note, it is called a return because a portion of the Federal Reserve notes that have come in are sent back, restored, redelivered, that is to say, returned to their lawful owner, the Federal Reserve Bank, in exchange for privilege of their use. President Ronald Reagan's private sector survey on cost control on the subject of income taxes reported as follows. Quotes, 100% of what is collected is absorbed solely by the interest on the federal debt and by federal government contributions to transfer payments. In other words, all individual income tax revenues are gone before one nickel is spent on the services which taxpayers expect from their government. Note that the two entities cited in the definition above are both corporate, artificial persons, and individual is a public corporation of one. A corporation is a corporation aggregate. This is why officer of a corporation is the only extraneous entity cited in Internal Revenue Code definition of employee. Taxpayer, one who is subject to a tax on income, regardless of whether or not he or she pays the tax. Internal Revenue Code 7701A14. See note. Note, being a public corporation and an individual, the trade name is the one who is subject to a tax on income, but the strawman does not, indeed cannot pay the tax. You, as the strawman's surety, pay the tax on its behalf. Tenor. By the tenor of an instrument signifies the true meaning of the matter therein contained. Cowell, Bouvier's 8th. Title. In law, a legal right to the possession of property, especially real property, the ground or evidence of such right, the instrument constituting evidence of such right, a unity combining all of the requisites of complete legal ownership. Also, ownership, a term used in property law to denote the composite of facts that will permit one to recover or to retain possession of a thing. Webster's. See note. Note, your birth certificate is only a certificate of title in reference to your strawman and confirms only that the issuer of the certificate held the actual title at the time of registration. The issuer may have since assigned, sold, transferred the original birth document. You are the source, origin, and cause of the property registered in the birth certificate, the corporate, all capital letters trade name of your strawman. As its surety, you bear all liability for its misadventures in the public sphere, including being personally, financially responsible for its, quotes, fair share of the national debt and any other penalties and charges associated with its name. You are also the only one referenced and identified on the original birth document. Mother, father, place of birth, exact minute of birth, footprints, handprints, eye color, weight, height, length, blood type, etc. Accordingly, you have the supreme claim of the title of your birth certificate. To reclaim it and redeem it, all you need to do is speak up in the proper form and in the proper manner. See Document of Title. Title, second definition. The radical meaning of this word appears to be that of a mark, style, or designation, a distinctive appellation, the name by which anything is known. Thus, in the law of persons, a title is an appellation of dignity or distinction, a name denoting the social rank of a person bearing it, as quotes Duke or Count, blacks first. Note the title Esquire, flaunted by most attorneys in America, is a title of nobility, the granting of which is prohibited by the Constitution. In the British class system of contemporary feudalism, signifying status above the rank of gentleman and below the rank of knight. Tort, wrong, injury, the opposite of right. So called according to the Lord Coke, because it is wrested or crooked, because being contrary to that which is right and straight. In modern practice, tort is constantly used as an English word to denote a wrong or wrongful act, or which an action will lie, as distinguished from a contract. A tort is a legal wrong committed upon the person or property independent of contract. It may be either 1. A direct invasion of some legal right of the individual, 2. The infraction of some public duty by which special damage accrues to the individual, 3. The violation of some private obligation by which like damage accrues to the individual. In the former case, no special damage is necessary to entitle the party to recover. In the two latter cases, such damage is necessary. See note. Note, torts are a fabrication and a fraud. In order to keep judges from having criminal charges filed against them, a way of cheating on the rules was needed in order to stay in business within the system, wherein a civil charge could be converted into a criminal charge and vice versa. The solution was a third system of law within the courts called torts. Torts means a twisting. When words such as accused of, counts, and fraud appear in a civil complaint, it is said to be in the nature of a criminal process. Since it is in the nature of a criminal process, one can respectfully reserve the right to remain silent and not a witness against himself. All interrogatories are thereby thwarted, there is no discovery, and the tort claim is killed. They must proceed criminally with a jury trial, and it's all over because it isn't simple for them anymore and it's no longer profitable. That's how tort claims are stopped. Trade name. A trade name is a name which by user and reputation has acquired the property of indicating that a certain trade or occupation is carried on by a particular person. The name may be that of a person, place, or thing, or it may be what is called a fancy name, that is to say, a name having no sense as applied to the particular trade, or a word invented for the occasion and having no sense at all. Blacks first. See note. Note, any alphabetical variant of someone's true name set forth in all capital letters, abbreviated format so as to express an item sonans legal construct that signifies a juristic person, a corporate entity, as well as any other type of artificial contrivance such as a corporation, trust, partnership, quotes, doing business as, and the like. A trade name functions as a transmitting utility in commerce for and on behalf of the man or woman. In accordance with the law of the flag, a trade name is artificial, abstract, and corporate in nature while a man has physical existence. Trade names are not the equivalent of the man or woman on whose behalf the trade name functions as a flag, transmitting utility, or proprietary trademark. Trademark. Noun. 1. A word, phrase, logo, or other graphic symbol used by a manufacturer or seller to distinguish its product or products from those of others. The main purpose of a trademark is to guarantee a product's genuineness. In effect, the trademark is the commercial substitute for one's signature. In its broadest sense, the term trademark includes a service mark, often shorthanded to mark. Black 7th. Trading with the Enemy Act of October 6, 1917. During the time of war or during any other period of national emergency declared by the President may, through any agency that he may designate, or otherwise investigate, regulate, or prohibit under such rules and regulations as he may prescribe, by means of licenses or otherwise, any transactions in foreign exchange, transfers of credit between, or payments by banking institutions as defined by the President, and export, hoarding, melting, or earmarking of gold and silver coin or bullion or currency by any person within the United States or any place subject to the jurisdiction thereof, and the President may require any person engaged in any transaction referred to in this subdivision to furnish under oath complete information relative thereto, including the production of any books of account, contracts, letters, or other papers in connection therewith in the custody or control of such person, either before or after such transaction is completed, and such other individuals or body or class of individuals as may be natives, citizens, or subjects of any nation in which the United States is at war, other than citizens of the United States, wherever resident or wherever doing business, as the President, if he shall find the safety of the United States or the successful prosecution of the war shall so require, may by proclamation include within the term enemy. Note: a government's tactic of fostering emergencies and stepping in as hero to extricate the people from the difficulty by dramatically increasing state power is as old as government itself. The U.S. bankruptcy occurring in 1861 placed the country under emergency war powers, which has never been repealed and exists in the Title 50 United States Code, Sections 212, 213, 215. Appendix 16, Title 26 Code of Federal Regulations, Chapter 1, Section 303.1 through 6A, and Title 31 CFR, Chapter 5, Section 500.701, Penalties. The Civil War was not fought over slavery, but over private bank control of America. On October 6, 1917, the United States passed the Trading with the Enemy Act, House Resolution 4960, Public Law 91, granting itself extraordinary additional powers under the cover of World War I. On March 9, 1933, just after Roosevelt's inauguration, Congress passed the Amendatory Act 48, Statute 1, to the Trading with the Enemy Act at a time when the United States was not in a shooting war with any foreign foe. Government had become an administration for the creditors in bankruptcy. The amended version provided legal justification for dramatic increases in the power, scope, and authority of the U.S. government, now owned by and an administrative agency of the Federal Reserve International Monetary Fund bankers. Aspects of such increase are The President became, quotes, king, unquote, via Section 1 of Title 1 of the Act. Quote, the Act's regulations, rules, licenses, orders, and proclamations heretofore and hereinafter taken, promulgated, made, or issued by the President of the United States or the Secretary of the Treasury, pursuant to the authority conferred by the subdivision B of Section 5 of the Act of October 6, 1917, as amended, are hereby approved and confirmed, unquote. This means that anything the President wants to do is approved and confirmed automatically in advance, as to say, hereinafter, and backed by the full force, effect, and power of the government, unquote. Title 12 U.S.C. 95A states in part, quote, A, in order to provide for a safer and more effective operation of the national banking system and the Federal Reserve System, indicating that the President acts for and on behalf and under the direction of the Federal Reserve during such emergency period as the President of the United States, by proclamation, may prescribe. Every president since Roosevelt has reaffirmed the national emergency and issued executive orders under 12 U.S.C. 95A and continued the reorganization of the country in favor of the Federal Reserve IMF bankers. Since March 18, 1968, Title 31 U.S.C. 5112 and Title 31 U.S.C. 5119, Federal Reserve notes have not been redeemable in silver. In 1971 through 1973, President Nixon declared total international bankruptcy, rendering private Federal Reserve notes unredeemable, non-negotiable floating pieces of paper as a medium of exchange. These notes are listed in Title 26 U.S.C. 165G as, quotes, worthless securities, unquote. The original Trading with the Enemy Act excluded citizens of the United States from being treated as the enemy when involved in transactions wholly within the United States. The Amendatory Act of March 9, 1933, however, included the people of the United States as the enemy by inserting the following, quote, by any person within the United States or any place subject to the jurisdiction thereof. Chapter 1, Title 1, Section 1b. By operation of law, all persons, that is to say, citizens of the United States, involved in the monetary transactions within the United States became official enemies of the U.S. government and as such required a license for almost every type of commercial activity imaginable. The fact that sovereign Americans do not qualify as, quotes, persons within the United States, unquotes, and hence are not subjects of the legislation, was not explained for them by the U.S. government in 1933, nor any time thereafter, and never will be. Trading with the enemy. The federal offense of carrying on commerce with a nation or with a subject or ally of a nation with which the United States is at war. Black Seventh. Transmit. To send across. Transitive verb. To convey or pass along. An impulse, force, motion. Webster's. Transferred for value. See UCC 3-303. Value and consideration. Transmitting utility. Transmitting utility means a person transmitting utility means a person primarily engaged in the business of any of the following: A. Operating a railroad, subway, street railway, or trolleybus. B. Transmitting communication electronically, electromagnetically, or by light. C. Transmitting goods by pipeline or sewer. D. Transmitting or producing and transmitting electricity, steam, gas, or water. UCC 9-102A80. Filing office for transmitting utilities. The office in which to file a financing statement to perfect a security interest in collateral, including fixtures, of a transmitting utility is the Office of the Secretary of State, UCC 9-501B. Transmitting utility financing statement. If a debtor is a transmitting utility and a filed financing statement so indicates, the financing statement is effective until a termination statement is filed. UCC 9-515F. See note, transmit utility. Note: we all use in some degree electricity, steam, gas, water, telephone service, sewer service, etc. in our life. The bills for these services come in the trade name of our strawman, but we are the ones who must pay. These services are accessed, that is to say, transmitted, by virtue of the strawman trade name. In those all capital letters written fictitious name, we have a nexus with the public venue. Your strawman interfaces between you and the public industrial society. He transmits on your behalf from the public venue into the private venue all manner of services that are available only from the public venue via artificial person trade names, as to say strawmen, whose names appear in all capital letters. The term utility is patent. Law means, in quotes, industrial value, the capability of being so applied in practical affairs as to prove advantageous in the ordinary pursuits in life, or add to the enjoyment of mankind. Flesh and blood men and women can enjoy value. For the industrial community, that is conveyed, set, transferred, and transmitted for their use by a transmitting utility. The proper venue for filing when the debtor is a transmitting utility includes fixtures, goods intimately related with real property, is the Office of the Secretary of State per both Revised Articles 9, UCC 9-501, and previous Articles 9, UCC 9-4015, and not the County Records Office, as with all other types of debtor filings. However, anyone with real estate holding should also file a financing statement in the office of the county or county recorder or clerk wherein the real estate is located. Also, there is nothing prohibiting anyone from recording such filing in the office of the county clerk recorded if desired. Under Revised Article 9, the location of the debtor, not the collateral, is the proper jurisdiction for almost all filings, but in case of any doubt, a filing could be filed in any jurisdiction where collateral is located as well. Per Revised Article 9, UCC 9-307, individual debtors are considered located at the individual's residence. Corporations and limited partnerships are located in their state of organization. The transmitting utility filing is also permanent per both Revised Article 9, UCC 9-515F, and previous Article 9, UCC 9-403-6, and need not be renewed every 5 years like other types of filing, more evidence that this route constitutes remedy. Traverse. In the language of pleading, a traverse signifies a denial. Thus, where a defendant denies any material allegations of fact in the plaintiff's declaration, he is said to traverse it, and the plea itself is thence frequently termed a traverse. Blacks first. Traverser in pleading. One who traverses or denies. A prisoner or party indicated, so called from his traversing the indictment. True. Conformable to fact. Correct. Exact. Actual. Genuine. Honest. In one sense, that only is true which is conformable to the actual state of things. In that sense, a statement is untrue which does not express things exactly how they are. But in another and broader sense of the word true, as a synonym of honest, sincere, and not fraudulent. Blacks first. True bill. In criminal practice, the endorsement made by a grand jury upon a bill of indictment, when they find it sustained by the evidence laid before them and are satisfied with the truth of the accusation. See note. Note, a true bill, both in criminal practice and in commerce, is a ledgering, is a bookkeeping accounting, with every entry established via affidavit, certified and sworn as the responsible party's commercial liability as true, correct, and complete, and always contains and is characterized by a one-to-one correspondence between items, services purchased, and offenses committed and the corresponding debt owed. This commercial relationship is what is known as just compensation, 5th article of the Amendment of the Constitution. In the relationship between the government and the American people, a true bill is called a warrant, 4th article of Amendment of the Constitution. And the direct taking of property by legislative act, for example by Federal Reserve's Internal Revenue Code, is called a bill of pains and penalties. Constitution, Article 1, Section 10, Clause 1, and Article 1, Section 9, Clause 3, Bill of Attainder. True name. When a defendant is indicted or prosecuted by a fictitious or erroneous name, and in any stage of the proceedings his true name is discovered, it must be inserted in the subsequent proceedings, referring to the fact of his being charged by the name mentioned in the indictment or information. Oklahoma Statutes, Chapter 22, Section 403. Quote 17b, if you check the yes box in line 17a, give applicant's true name and trade name, if different than names shown in prior application. Internal Revenue Service Form SS4, application for employer identification number. 2. Please tell us about yourself. Use your true full name. California Department of Motor Vehicles Form DL44, driver's license or identification card application. Note, see legal fiction. Compare fictitious name. Note, the term true name is used whenever such inclusion may benefit actors in the government, but is not specifically defined as such in the law dictionaries that government actors draw from. Defined in Black's 4th within the definition of another term, fictitious name, per the rules of English grammar and the prescriptions of law, only initial letters of the man or name of men or women, a proper noun, are capitalized. The combination of one's Christian given names plus one's family name or surname, when written in this manner, constitutes one's true name. Newspapers, when naming defendants and those convicted of a crime, always properly state the true name in proper English of the targeted party. Names falling outside the rules of English grammar are artificial constructs and exist only by force of or in contemplation of the law, that is to say, are corporately colored. Government or judicial use of an all caps spelling is a presumption irrespective of the facts. A true name, like a trade name, is property and can be copyrighted. Appellation is a superior concept in reference to both true and trade name, and must be grasped to enjoy sovereignty. Trust fund. The property held in a trust by a trustee. Black 7th. Trust fund doctrine. The principle that the assets of an insolvent company, including paid and unpaid subscriptions to the capital stock, are held as a trust fund to whom the company's creditors may look for payment of their crimes. Black 7th. Truth in Lending Act. This regulation, known as Regulation Z, is issued by a Board of Governors of the Federal Reserve System to implement the Federal Truth in Lending Act, which is contained in Title I of the Consumer Credit Protection Act as amended, Title 15 U.S.C. 1601. The consumer may exercise the right to rescind until midnight of the third business day following consummation delivery of the notice required by paragraph B of this section, or delivery of all material disclosures, whichever occurs last. Title 12, Code of Federal Regulations, Chapter 2, Truth in Lending, Regulation Z. Alright, and from there, we will begin the U's next time. Thanks for listening.